A group of states, including Ohio, Missouri, Georgia, and Alabama, passed new strict restrictions on abortion last month. They kicked off a constitutional battle that's reverberated across the country and appears headed for the Supreme Court. Many of the new laws would prohibit abortion after the first 6 or 8 weeks before most women know that they're pregnant. But the measure in Alabama takes it even further, banning all abortion, including in cases of rape and incest, unless the mother's life is at risk or the fetus cannot survive, with up to 99 years in prison for doctors who don't comply. These new restrictions are obviously unconstitutional, at least under current law, and that is the point. Anti-abortion activists are hoping to take the case to the Supreme Court and repeal Roe v. Wade, the 1973 Supreme Court decision that first legalized abortion nationally. But supporters of abortion rights aren't just waiting for legal challenges to play out. Several states, including New York, Illinois, Vermont, and Nevada, have answered the restrictions and bans with new laws of their own, codifying and expanding abortion protections at the state level. And with a new bill pending on Beacon Hill, Massachusetts could be next. The bill's sponsors are calling it the Roe Act, and it would expand abortion access laws already on the books by giving doctors the discretion to perform abortions beyond the current 24-week limit, by eliminating the requirement for teenagers to get parental consent, and by barring the state from interfering with or restricting abortion access. Lawmakers on Beacon Hill will take up the bill in a hearing next week. Joining me are Rebecca Hart Holder, the executive director of NARAL Pro-Choice Massachusetts, which is in favor of the Roe Act, and C.J. Williams, the community engagement director for Mass Citizens for Life, which opposes it. Thank you both for being here.
Thank you. Thank you.
Rebecca, let me start with you. Why is this legislation necessary?
Well, we know that with Justice Kavanaugh's ascension to the Supreme Court, anti-choice forces got a very clear signal that this was the moment to challenge Roe v. Wade. Massachusetts has historically led on universal access to health care, on gay marriage, and we believe it's an appropriate moment to lead on abortion access. We think it's an issue of gender equality, and we think it's time to make a national statement.
CJ, I know that you oppose this bill in its entirety. Are there particular parts of the bill that Mass Citizens for Life believes are extremely problematic?
I think so. They're particularly problematic whether you're pro-choice or pro-life, because one of the first two things this bill does is endanger our children by removing adult supervision, and it removes all restrictions and all regulations that allow women who are experiencing a late-term abortion to have a physician attending, and to have those performed in hospitals. And we have the best hospitals probably in the nation. Why in the world would we no longer require that a really important medical procedure be performed there?
Let's take those one at a time. In terms of the requirement that this bill would eliminate, and tell me if I'm getting anything wrong, both of you, please, but my understanding is that it would no longer be required for a minor to get a guardian's consent to get an abortion. Why is that smart policymaking as you see it?
That's right. So Massachusetts is an outlier in New England. It has one of the strictest laws around teens getting abortion care. We know that the vast majority of teens, over 73%, bring a parent or guardian with them when they are facing an unintended pregnancy and when they're trying to make a decision and go to an independent provider or to Planned Parenthood. But for the other 27% who for some reason cannot get a parent's permission to get abortion care, they go through what's called the judicial bypass process. That's where a judge makes a determination on whether or not the minor is mature enough to decide if she can have abortion care. It disproportionately impacts low-income teens and teens of color, and we find that to be an intolerable result. We believe that teens need counseling, they need support, they need help. Sometimes they need social services when they're faced with an unintended pregnancy, and they don't find that in the judicial bypass system.
CJ, how do you respond to that argument for the change?
They need support, and yet we don't want any adults involved. That seems to be a contradiction in terms to me. Many investigations have been done on teens seeking abortions. When there's no adult involved, the adult that ends up involved is a sexual predator, and that's not fair to our teens.
When you say the adult who becomes involved is a sexual predator,
yes.
Is the idea there, I'm not familiar with this argument, that it's someone who has gotten a teenager pregnant?
Exactly.
And I think judges are in exactly the wrong position to determine if someone's trying to coerce a teen or abusing a teen. I think trained counselors who know how to spot coercion and abuse are exactly the right people. Look, in a best case scenario, we want parents involved. I'm a mom. I want to be involved in my kids' decisions. But we can't legislate family communication and family dynamics. And that's why we can't create a one-size-fits-all solution. And we need to remove a law that disproportionately harms already vulnerable teens.
What about CJ's argument? And I've spent a lot of time in the last couple of days going back and forth looking at the current law and the bill, but this stuff is very subtle. I missed the part that you were talking about when it comes to removing medical access. Is she correct that a certain level of medical access and hospital care would be eliminated if the Roe Act passes?
No, she's not correct. It is absolutely the case that we have the best health care in Massachusetts, probably in the nation. And we want some of the most medically complex cases to be handled here in Massachusetts. And that's what the Roe Act would do. It would remove barriers when a family is facing a lethal fetal diagnosis so that they could get that care. Right now, there are a lot of freestanding clinics that offer extremely high quality abortion care throughout the nation. And so we are not limiting care to those places, but we certainly are not foreclosing hospitals from providing the extraordinarily high level of care that they already do.
So why are we discriminating against people who are minorities or who have less care? We're saying, well, actually, let's just put you not in a hospital because it's harder for you to access it. You know, we'll just take out that thing. We're really not protecting our minorities.
Are you talking about the elimination of the language that says currently under state law that under 24 weeks an abortion must be performed by a physician? Is this what you're talking about here? Okay.
That and that 24 weeks and beyond must be performed in a hospital by a physician.
So I think we're actually doing the opposite. Right now, if you're a family who faces a lethal fetal diagnosis, something that no family would ever want to go through, what happens is that they're told you can either carry the pregnancy to term or you can travel across the country to get abortion care. We don't support both decisions. In Massachusetts, we're telling people you have to leave the state, you have to leave your community of support, you have to leave the physicians that you trust, and you have to go elsewhere for that care. What we're trying to do is change that and keep you at home if abortion care is the decision that's right for your family.
CJ, let me ask you about the lethal fetal anomaly piece. Why is it problematic from MCFL's point of view to tell a woman who is carrying a, whatever term you want to use, fetus, child, that is not going to be able to live after birth, you need to carry that child, pardon me, you do not need to carry that child to term? Because if I understand it correctly, that's what the Roe Act would do. It would give you the opportunity to abort if the fetus was not viable. Am I wrong about that?
The testing on this is really iffy. Many children who have been given diagnoses have survived. Some who never get diagnoses don't survive. It's a very small percentage. I think a really important part of this is it seems really elitist to legislate small percentage and say we're going to remove regulations that protect our women from a dangerous procedure because a small minority might suffer some distress in the fact that they cannot terminate. And really this goes back to that, like, okay, again, I have the means, I'm upper class, I can travel if I need to get an abortion. If I can't, you know, the baby may not survive, but at least the woman will be taken care of in a hospital.
But let me ask you, and this is kind of dicey because I'm in fact a man and I'm not capable of carrying a child, just to put that on the table.
You're a reporter here,
but
so.
I would imagine, I can imagine trying to think it through, being a woman who has learned, all right, the child that you are carrying, or the fetal, again, whatever term you want to use,
the human being
the being in your womb is not going to remain viable after birth.
Right.
And I can imagine it being incredibly painful to not have the option of ending the pregnancy there,
So
and to have to go through 9 months.
Understood. On that logic, then, should a mother of a toddler who's given a lethal diagnosis be able to expose the baby because it's going to be so painful for her to watch that baby die? What's the difference? Or are we opening it to that? Because that's the logic there. Is this baby won't survive. It's going to be really hard for me to watch and care for this human person. Do I just leave him out? Yeah.
I think the logic is that this is a deeply personal decision. This is a decision that no parent wants to go through. And when you're faced with a devastating diagnosis, you should be able to make the decision in consultation with your family, with your community, and with your physician. It isn't for the legislature to decide when it's appropriate for you to get abortion care, and it's certainly not for advocates to decide.
In the legislation, is there anything that would prevent a mother who was carrying a fetus or child that was maybe going to run into trouble in the early years, might not survive past 2 or 3, that would prevent them from aborting or not?
What we're doing is we're leaving this up to physicians and we're leaving it up to families because we trust them. I just don't believe we can create a bright line rule that captures all of the complexity of pregnancy in a way that makes it so that it's very clear what you do. In my opinion, women have to be trusted and doctors have to be trusted.
We have to wrap up soon, but I'm going to cheat a little bit into the next segment because I want to play for both of you comments that Governor Baker made when he was asked about this bill, this proposal, fairly recently. Let's take a look.
I don't support late-term abortions. I support current law here in Massachusetts. It's worked well for decades for women and families here in Massachusetts, and that's what we support.
So I guess a double-barrel question here. Doesn't the governor's comments, or don't the governor's comments, suggest on the one hand that the Roe Act is not going to go anywhere, and on the other hand that your legislative agenda, which, if I read it correctly, includes a proposal to ban abortions on after 20 weeks, period, flat out, with no exceptions, doesn't that mean that your agenda is going nowhere and that the Roe Act is going nowhere?
Well, Governor Baker actually said in response to a question from Marjorie Egan that he does not support women traveling out of state for abortion care. So I think we're doing some education with the governor. I look forward to having a conversation with him. He's been great on pro-choice issues last legislative session, and I think when we have the opportunity to speak with him about the situations that real families face, that he's going to get it.
And do you think you can sway the governor?
It is very telling that someone who is radically pro-choice and supports abortion in Massachusetts does not support the Roe Act. Because we just did a poll recently, and 74% of Massachusetts voters, most of whom identify as pro-choice, liberal, or moderate, do not support expanding late-term abortion or removing hospital regulations.
And we got to leave it here. My understanding is the poll didn't talk about lethal fetal anomalies, for example.
It did. That was one question.
Okay, people can look it up online. C.J. Williams, Rebecca Hart Holder, thank you both for being here.